The broadcast has started, so good evening, dear colleagues. The Competition Commission on the selection of HQCJ members keeps working, and now we have an interview with Yaroslava Volodymyrivna Kravchenko, who is a candidate who applies for the position in the HQCJ Commission of Judges under the quota of judges or retired judges. Greetings, greetings, Madam Yaroslava. Good afternoon. Yes, good afternoon. So for someone it's afternoon, for someone it's evening already. So Madam Yaroslava, this interview will be carried out in the following manner. I will introduce you very shortly. Then you will have some time for self-presentation. You will have up to 5 minutes to tell us about your motivation and why you decided to participate in this competition. What actually motivated you? And to your opinion, what do you think you will bring as additional value to the HQCJ as a potential candidate for the position of the member of HQCJ? Then our commission members will ask you questions one by one. If we have enough time, we'll have 2 rounds of questions. If we don't have enough time, we'll have 1 round of questions. And at the end of the interview, you will have an opportunity to wrap up this interview, maybe to pay our attention to something, or maybe to mention something what would not have been mentioned during the interview. That's the procedure of our interview. Any questions before we start? No, all is clear. Thank you. Then let's start the interview with the candidate, Yaroslava Kravchenko. The competition commission is here at its full composition. My name is Ivan Mishchenko, and my colleagues, Robert Brochain, Evgen Mezentsev, Sergei Varlanov, Stephen Markman, and Ted Zazhechny. Our candidate is Yaroslava Kravchenko. She works as a judge of the Slovensky District Court in the city of Kiev. She started working there last year, and she has been appointed on 10th of May. So she has been working in this position for a little than 1 year. Her legal experience, working experience, is 16 years old. She lives in the city of Kiev. Now I give a floor to you, Madam Yaroslava. Please tell the Competition Commission, maybe our viewers, about your decision to participate in this competition. Please, over to you. Thank you. I would start my presentation and my motivation with telling you about my professional experience. As some mass media mentioned recently about my small working experience as a judge of the local court of general jurisdiction, yeah, it's true, but at the same time, I will show you some cases, some examples, which I have faced during my working experience. So I have general working experience 19 years and legal working experience 16 years. For you to better understand what were my activities, maybe it would add some characteristics to my professional features. When I was a student of the second year at the university, I participated in the competition and I was appointed as a secretary of court sessions. So I have worked at that court for 10 years. I started with from the position of the Secretary of Court Sessions and ended as the Chief of Staff of that court. So I actually went through all the positions and I understand the structure of courts from the very beginning till the very end. When in 2015 the NABU has been established, I realized that I have, at that moment, I have already worked at the position of the Chief of Staff and Deputy Chief of Staff of the court for 3 years. So I decided to participate in the competition for the NABU and to try myself as a specialist. So I participated in that competition. I was successful in that competition. I appointed first as the head of the work with the applicants and witnesses, and then as the head of the public relations department. I would like to say that I was appointed for the position of the NABU almost after it was established. And we, as heads of different units, we needed to handle different issues of internal communication and internal interaction between different units, and also take into consideration the specifics of activities of our directorate. We needed to handle issues of interaction with civilians, with citizens. When I worked at that role of the head of the directorate, yes, indeed, we were actively working with the main subdivision of detectives of the NABU, and I need to say that that under our functions and responsibilities, we needed to communicate, not only to communicate with citizens in different manners, but also our directorate was responsible for primary processing of all applications, inquiries, and requests submitted to the NABU according to the procedure which was approved by the director of the NABU at that moment, according to the law of Ukraine on the NABU, and according to the regulations which were developed by our department with involvement of the main directorate of detectives and legal unit. So yeah, just to remind you, Terry, I want to slow yourself a little bit. Yes, of course. After the beginning of the full-scale invasion in 2022, when so many different authorities, how to formulate it, so many different authorities were suspended their operations, their activities. So mainly all activities were focused at law enforcement sector, at actually identifying traitors and so on. So it means that there were not so many requests submitted to law enforcement authorities in terms of anti-corruption signs and anti-corruption suspicions. So because it was the times like that. And as each organization, each public authority wanted to be useful, as each head of each public authority wanted to be useful, and also based on my initiative, and of course in approval with the leadership of the NABU, there was an agreement concluded, like a memorandum of understanding concluded with the National Information Bureau. And for 3 months, our directorate carried out receipt and processing of applications, letters, and inquiries from persons who informed us about missing persons, and also captured persons on the occupied territories and territories where hostilities took place. As actually the NABU is also responsible for this issue, and the National Information Bureau has just been established. They experienced staff shortage. They didn't have enough information database. That's why our technical equipment was provided for their support, and we provided our support them in this process. But further, when the National Information Bureau has been duly established, we've already stopped this interaction, and our staff has received relevant awards for providing the support. And I think that at that moment, it was extremely important. And as I participated in the competition for the positions of judges in local courts, which was announced back in 2017. So I participated in the competition. I also had a training in the School of Judges for 9 months. And after the reform and after the previous composition of the HQCJ stopped functioning, our selection our competition actually was prolonged and was lasted for 7 years. Our candidates have passed different tests and exams, and based on information which was available at that legal field, it was not sure whether this competition would end successfully or not successfully.
In 2023, when the HQCJ resumed its activities, it was clear that the competition was not over, and I decided to change my sphere of activities from the perspective of probably the fact, maybe it would sound strangely, but I wanted to leave the comfort zone. Probably like that, because when your work is already organized and when you're the head of the department and all the directions are properly functioning, then the main thing is to make sure that everyone performs their duties. I changed my sphere of activities, and since August of 2023, I've been the national expert on the reform of the prosecutor's office in idea law. During 8 months of my work in this, while working there for 8 months, in my opinion, in joint cooperation with my colleagues and other public authorities and other international experts, I think we achieved significant results during a short period of time. In particular, 2 projects were implemented. One of the projects was about the reform of public reception in the Office of the Prosecutor General, based on which subsequently the reforming of the Kyiv Prosecutor's Office took place. And there arose such an issue due to the martial law period regarding extradition of persons to Ukraine, because there were many decisions of the European Court of Human Rights regarding established violations in the form of torture, and of course, violations of conditions of the martial law. One of the comprehensive measures was adoption of the strategy on fight against torture in the law enforcement sphere, which was adopted last year, in particular in August. And for that, we conducted lots of work. So we developed the draft strategy, we developed regulations to each clause of the strategy, we analyzed the legislative framework, we conducted meetings with respective public authorities, and then I was appointed to the position of the judge of the local court of general jurisdiction. I would like to point out that since I joined the judiciary system when I was 19, I always had this motivation. I knew for sure that I would take part in competitions. Maybe it did not happen as quickly as I would love that, but however, the judiciary is a part of my professional activities. It was, is, and will be. Taking into account that now, as a participant of the lawn competition with all, not to say shortcomings, but some peculiarities, because this competitive selection took place as a result of the reforming of the procedure. And now I'm the representative of the local court of general jurisdiction, which makes me the witness of all problematic issues faced by local courts of the general jurisdiction, which have significant workload, which are the majority of local courts. So, given my previous experience, in my opinion, it allows me possibilities and analytical capacities to see problems, and I would really want to contribute probably to the restoration of trust in the judiciary that is directly related to the functioning of judges who now work in the conditions of the crazy workload, especially with respect to judges of local courts of general jurisdiction. I'm convinced that I have those skills and knowledge and willingness to become closer. I cannot say to make, because it will not depend only on me, but I'm ready to do everything possible so that citizens were not obliged to wait for court decisions for years, so that judges could work during the normal mode and to get satisfaction from their job. And so that candidates for positions of judges would want to become judges. And that's it. If you have any questions, maybe I will clarify some of my words. Thank you. Thank you. Quite detailed presentation of your professional career. Madam Yaroslava, I will start asking questions. My first question is obvious. You worked as a judge for slightly more than a year. Yes. And immediately you decided to take part in this competition. Yes. It took you a while to get the position of the judge, right? Why now? Because I have inspiration, willingness, and knowledge and strength. That's firstly. And secondly, in case of successful completion of the interview and my recommendation, contrary to other members of the HQCJ, I will not have the right to take part in other competitions. I will go back to work as the judge of the local court of the general jurisdiction, where I will continue working after that. The reform is prolonged. Maybe it has some of its own shortcomings, successes. I believe that right now, my knowledge, my age, allow me to do that. Regardless of the fact that I was working as a judge for only a year, I think that now it is high time for me. This is the time when I want to join the process of working in the HQCJ, not from the perspective of a job as being the job, but from the perspective of my desire to bring some other views, maybe some, it doesn't, okay, I've understood your point. Thank you. You're saying that while working in the judiciary system, you've seen and now you see all those problems and complexities faced by the system. In your opinion, which problems and complexities can be resolved by the HQCJ with you in it? Tell me, please, can I talk in general about everything at once? So should I describe each separately? You have a team in the court and you communicate with colleagues just like everyone does in courts. In your opinion, let's imagine you are the member of the HQCJ. Let's imagine you work for 4 years there. In your opinion, what should you do so that once you go back to your court, your team will meet you and will tell you, you know, yes, you've done a great job. Like, we are sincerely grateful to you for your work. In your opinion, what should you do? If we're talking only about the court stuff, then after 4 years, when I go back to the court, all the vacant positions would be filled in, and that's something to say thank you for. That's if we're talking about judges from the court. Okay, filling in vacant positions of judges. Okay, the HQCJ can do that. And my last brief question to you is the following. Tell me, please, the HQCJ is related to work with people in many respects. Quite often in the mass media, they simplify and say that the HQCJ is the HR manager of the judiciary. So what do you have in your professional experience that you could point out in the context of work with people? Maybe you took part in some procedures, some selection procedures, maybe you hired people or conducted their appraisal. So what could you use from your professional experience in this particular capacity? While working in the National Anti-Corruption Bureau, where free HR commissions were adopted, I was one of the members and the deputy head of one of the selection commissions for about 5 years, if I'm not mistaken. And since this was only the start of the work of the National Anti-Corruption Bureau of Ukraine, we had lots of competitions ongoing. For example, we could have 100 candidates for one position. These are the same checks of documents regarding competitive selections. We are talking about the check of documents, check of integrity. Each selection commissioner had representatives of the Public Oversight Council. That's not the same, but if we are talking about competitions, then we conducted special check of documents, check of compliance with requirements. Okay, I've heard you. That you consider to be your relevant experience. Then, while being the expert, I was also the member of competition commissions on the selection of staff to the office of the Prosecutor General. Thank you. For now, I have no more questions. And now I'm passing the floor to my colleague, Ted. Please, Ted, the floor is yours.
Thank you, Mr. Chairman. Ms. Kravchenko, I, along with my colleagues, of course, have reviewed your work history in detail. And I think it's fair to generally say that for approximately 10 years, you worked in administrative capacities in support of the work of your court, the District Court of Kremenchuk. And then you subsequently spent approximately 7 to 8 years with the National Anti-Corruption Bureau. And then you spent a brief period of time with IDLO, and then you were a judge for 9 months, approximately, when you applied to the commission that we serve for this position on the HQCJ. Of those experiences, which in your opinion, and for what reasons, do you feel they most qualified you for your work as a member of the HQCJ?
I would not single out which particular experience. All the experience is very varied, and all experiences in combination give me the possibility and give me the understanding and professional skills to work in the HQCJ. From the perspective of work in the judiciary, that is the understanding of all the processes when we are talking about the court. Work in the NABU has given me organizational skills at a high level, I believe, including communication skills and organization of different processes, cooperation with different public authorities. While working as an international expert has given me the experience of analyzing legislative acts, draft regulations, draft legislation, including organization of processes, conduct of meetings, work in the selection commission. So the entire experience is multifaceted, and I cannot single out just one experience, because the work in the judiciary system has given me in-depth knowledge about the system, about its structure, about problematic issues, about the organization of the work of courts since the very beginning. Even about, if we are talking about, maybe that's not relevant to the work of the HQCJ, but I know about the methodology of determining the complexity of cases, the calculation of workload. So I cannot single out some particular experience. In my opinion, all of this experience is relevant.
All right, thank you for your answer. I'm concerned now to discuss with you your knowledge of the work of the High Qualification Commission of Judges. What do you understand about the work of the HQCJ? What now are the challenges that it faces, and how can you support the work to meet those challenges?
In addition to universally known challenges faced by the HQCJ that are available in the mass media, before the interview, I studied the roadmap adopted by the Cabinet of Ministers of Ukraine, and implementation of this roadmap is necessary for accession of Ukraine to the EU. And this roadmap sets out measures that the HQCJ has to implement, including deadlines. Right now, the HQCJ faces lots of issues with respect to the selection of judges to local courts, completion of selection of judges to courts of appeal, establishment of 2 specialized courts, including conduct of selection procedures to these courts, because that is also stipulated in the roadmap. They also have to conduct the competition to the appellate chamber of the High Anti-Corruption Court. And given that this composition of the HQCJ has 2 years of the authorities left, all of that has to be done very quickly. And all of these competitions are conducted simultaneously. In addition to all of these competitions, the HQCJ also has other functions, including adoption of a methodology on the reasoning of their decisions. With respect to the National School of Judges, they have to conduct the selection to the management of the National School of Judges of Ukraine, because it is cooperating with many other public authorities. That's briefly the key things that I could look through and to make some conclusions based on some regulations. But of course, another important issue is to complete qualification evaluation of judges, which like right now there are about 1,500, if I'm not mistaken, but more or less that's the figure.
All right. Yes, thank you. Have you studied the rules of procedure and the evaluation criteria of the High Qualification Commission of Judges?
Of course, I studied it. In April of 2025, the HQCJ adopted the regulation on qualification evaluation of candidates for positions of judges and judges, which are being brought to disciplinary responsibility, which are applied during the conduct of the interview, taking into account the unified indicators adopted by the decision of the HCJ. So yes, I studied the methodology, I studied the criteria, I studied how they put scores during the interview for each of the competences included for each of the competences envisioned by this regulation, and which are assessed by the HQCJ while conducting interviews with candidates or judges. This is the most recent regulation that is being implemented right now, but there are also other regulations and rules of procedure that are applicable to those judges who are undergoing primary qualification evaluation, and these rules of procedure and regulations were adopted earlier.
All right, thank you. One of the concerns that I particularly have with respect to the operation of the HQCJ is the role and responsibility of the Public Integrity Council. What is your view of the role and involvement of the Public Integrity Council in the work of the High Qualification Commission?
Public Integrity Council has been established, and it's also envisaged in the legislation based on the demand of the society as an authority which actually fosters work of the High Qualification Commission when they identify the level of integrity and professional competence of candidates for the positions of judges. Their role is important and crucial in society. It's a well-known fact, and it's actually, first of all, that's a demand of the society. But at the same time, in terms of cooperation with the High Qualification Commission of Judges, as we shall take into consideration that HQCJ cooperates together with the Public Integrity Council. HQCJ cannot accomplish the qualification assessment without conclusions of the Council. Unfortunately, the recent situation is the following, that the capacity of provision of such fundings is a little bit slower, and it impacts also on the qualification assessments. And in this matter, maybe it should be somehow improved with joint efforts, maybe for the Public Integrity Council, the quantitative indicator should be identified and regulated. So how many opinions it should provide? So to have some kind of stable figure, which should also be taken into consideration by the HQCJ. That's the first thing. And secondly, to my opinion, and I mentioned it in my motivation letter, and yeah, I think that it's already reflected in the roadmap, but maybe in a different manner, to create an analytical commission, which actually will be involved into the analytical work with having access to databases of candidates or judges. And they shall make opinions, shall make conclusions regarding those candidates and judges. Those conclusions shall constitute a part of their dossier. And we know that public integrity councils have access to the dossiers. That, first of all, would fasten and facilitate the whole process. It will also help to have institutional independence of the HQCJ, because now, based on the law of the judiciary and the status of judges, yes, HQCJ indeed reaches out to different public authorities and asks to provide information regarding candidates and or judges during the vetting procedure. Yes, of course, there are some set deadlines during which such public authorities shall provide answers to them. But whether indeed we can speak about 100% of independence and impartiality of this information, whether deadlines are complied with and so on, it also impacts on the workload of the HQCJ members, who then shall accumulate information, gather it together. But if we would have a responsible unit which will be responsible for this work, it will help also to decrease the workload
All
from
right.
the
Thank
HQCJ
you.
members.
Thank you for your answer. I am going to pass the chair back to the chairman. I want to make sure, sorry to interrupt you, but I want to make sure that all my colleagues have a chance to ask the questions that they have as well. Yes. Judge.
I have a question to you as the chairman, Judge Mashenko. Could we slow down the process just a little bit? I'm losing track of a little bit of the conversation. It's going quite quick, opinion.
Again, dear colleagues, let's speak slower, a little bit, half slower. Now I give a floor to Sergei Varlanov, my colleague. Thank you. Dear Yaroslava, in your speech, you mentioned that you see some problems in the judiciary during the time of you performing the role of a judge. As far as I understand, since 2006 to 2016, when you had worked in different roles at the Krukivsky District Court, did I understand you correctly? Yes, I performed different roles there. Good. Tell me, please, as of now, what problems do you see in the judiciary system? I mean, at this moment, for this period of time when you have been working as a judge. As of now, I see the following problems: to complete qualification assessments and to fill in vacancy positions in courts. It's a general problem, but can you please specify some specific problems? Okay, let's go to specific problems, specifically in courts, yeah? So from the perspective of the court system. Okay, so to my opinion, the issue of seconding of judges shall be regulated. I have mentioned it in my motivation letter, but this issue has already been regulated regarding seconding of judges. Okay, what problems specifically do you see in seconding of judges? So first of all, seconded judges are different. So first of all, we have judges who are seconded who are from the occupied territories from 2014 and then from 2022. That's the first thing. Secondly, the problem of clarifying and identifying the jurisdiction of courts, which were on the occupied territories but stopped functioning there. So now this problem is being regulated. But anyway, not always all those judges who are seconded to the courts which stopped functioning on the occupied territories, they don't always perform their work in the same courts. So that's the issue of seconding and the issue of jurisdiction, of course. What else? So yeah, so as I've mentioned, the issue of seconding of judges, the issue of jurisdiction of courts, then prioritization and order of filling vacancies in local courts. Okay, clear. How do you see your role and your added value as HQCJ member? We need to take into consideration that HQCJ is a collegial authority. There is no member who makes a personal, individual decision. So that's why my role, my ideas, my vision, as any of the HQCJ members, they shall be discussed. And as a final result, the decision shall be made, which shall make some sense to the judiciary system in general and to the HQCJ. So my actions and my decisions as a HQCJ member, they shall be made with huge social responsibility. Good. And you have participated in the competition for the position of the local court judge. And so to say you were a witness of all those procedures which were happening there, to your opinion, what should have been changed during those procedures? To my opinion, the studying period should have been changed in the School of Judges, so 9 months, and the procedure of studying, of learning. What specifically? What do you mean? So shall the period be reduced? Some subjects should be added to the curriculum, or what shall be changed in order for candidates for the positions of judges could gain more knowledge and skills, and what type of knowledge, theoretical, practical. So first of all, to shorten the procedure because the learning which lasted 9 months, it was too long time. There was so much theoretical material, and which actually is that material which we learned during our university studies. But, anyway, we have a requirement for candidates to have 9 years of experience. We don't need the theoretical material. And also, there should be more focus of attention at practical implementation, at experience at courts. There was so much unnecessary theoretical material which we were receiving during 9 months. Yeah, it could have been able to reduce this time at least by 3. Good, thank you, Yaroslava. Tell me, please, in one of your areas, you have mentioned that you would like to foster renewal of trust to the judiciary, including to judges. How would you like to try to do it? To my opinion, recovery of trust to the judiciary consists of 3 criteria. First criteria is integrity, second criteria is access to justice. So access to justice could be implemented only when vacant positions are filled in, and we will have even more vacant positions during the competition for the appellate courts. And qualification assessment also will happen when it's completed for those judges who have been administering justice for a long time. So that's one component. And second component, that's integrity. Integrity in this aspect shall be looked through those normative and legal procedures which are available for us already now. So integrity declaration, for example, HQCJ shall perform only those functions which it has according to the law, rather than taking other functions which are for the NACP or other law enforcement authorities. But at the same time, use available instruments. For example, integrity declaration, which is mentioned in the roadmap, which was suggested by the parliament to unite the integrity declaration and the family ties declaration. For now, I don't have any other views regarding the wettings for HQCJ. Thank you. Thank you. I've got your reply. And I would like to ask you, so during this time of you being at the role of a judge, maybe you were also a witness that some judges quitted their jobs at the court where you have been working. Yeah, unfortunately, at our court, a tragedy happened. Our female judge died, and another second judge, his secondment period was over. So it's over, and he, for now, does not administer any justice at the court. No, he doesn't administer justice at our court. Why do you think, at this moment, there is a huge number of sitting judges who quit their jobs? To your opinion, what shall be done in order for judges keep working, for them to be sure what will be tomorrow? That indeed the trust will be renewed, that they will keep working, and in such a way that they will do their professional activities in future. They will not be worried about their future. What do you think? What is the reason for that? We shall understand that the competition for the positions of judges at local courts has not been taken roughly for 10 years. I mean the difference between the first competition and the next competition. Of course, some judges already are ready to go to retire, and not all judges would like to work till 65 years old, administer justice till 65 years old. But giving a strict reply to your answer, there are also two components. First of all, that's a high workload of judges. So the workload causes a high level of high number of disciplinary complaints. So a judge is under stress, under huge workload, and maybe all this, impacts on lack of satisfaction from the work. So we have also vacant positions. Vacant positions which are in the courts also lead to increased workload. Secondly, maybe we have some kind of legal uncertainty. So yes, indeed, there is a qualification assessment which is not over. We have judges with 5 years, according to the previous law, who have not been administering judges for job for 8 years. Yes, they do some kind of job, but not administering justice. And before joining my position of the role of the judge in this court, actually a judge who has already been working 7 years, he just quitted his job because he was not ready to wait for the end of the qualification assessment. Thank you. Thank you for your replies. Now I give the floor to the chairman for further questions. Thank you. I give the floor to my colleague, Stephen.
Thank you, Judge Mishenko. And thank you, Judge Kravchenko, for your service on the court and at NABU and the work that you've done in both of those places. I'd like to follow up on some of the questions that have been asked about your experience, in particular, some of the questions that the chairman directed toward you. During this process, we have interviewed about 350 applications. We've looked carefully at those applications and tried to make intelligent judgments as best as we could about those 350 people. Of those 350 applications, there is only one person who initially refused to provide a letter of recommendation. And of course, that person was you. You were the only candidate who refused to abide by the rules of the competition and provide recommendations. after we requested those recommendations again, you did provide them. But I'd like to ask you about your refusal to provide the information, even though you knew it was part of the requirements of this competition. It was part of the rules of this competition. Is that an exercise in mature judgment on your part, or an exercise in inexperience?
So actually, the there's no reason related to my experience or my lack of wish providing such recommendation letter. Maybe I've got incorrectly this necessity or obligation from my side to provide recommendations. I based my decision on the following. How to formulate it. How to answer it to you. So, I thought that maybe it's, to boast myself, even if I'm boasted by other people. I don't know. And maybe I didn't get correctly the essence of recommendation, the nature of recommendation letters. I'm sure that I have so many people whom I can reach out and ask for recommendations to describe me as a professional. But I thought that, some essence, to some extent, maybe in order to avoid some kind of conflict of interest, it's if I'm frank with you.
Well, what concerns me even more than you not providing those letters of recommendation, what provides me with even more concern, and I ask you this because of your lack of substantial experience on the court, you're going to have to deal with the laws that have been made under the rules of Ukraine all the time. You won't agree with those. I was a judge for many years. I disagreed with many of the laws that I was required to be faithful to and to give respect to and to apply to the litigants before me. How do I take comfort that when you have to apply many laws of Ukraine, that you will not substitute your own judgment for that of the lawmaker in Ukraine? That is essentially what you did when you refused to provide the letter of recommendation. You said, I know that the selection committee, let me finish, please. I know the selection commission has this as a rule, but I don't think it's a good idea. But you can have a lot of laws that you know are the rule, but you don't think are a good idea. How are you going to deal with those?
May I clarify whether I understood your question properly? So, in case laws contain something that I do not like, what will I do in this case? That's the essence of the question.
That's a good way of putting it. Thank you.
Stephen's question is that he is asking you the following. When he used to work as a judge, and when we all work as judges, except for Robert, we apply laws, including the ones that maybe which we do not really like, but since they are laws, we apply them in our work as judges. And you, as a potential member of the HQCJ, will also have to work with the legislation of Ukraine. During this competition, there was a requirement to provide recommendation letters, but he did not do that. And in this context, Stephen is asking you, if you have not provided these recommendation letters in this competition, can it imply that you, as a potential member of the HQCJ, will not, for example, follow some requirements from some laws or bylaws, which in your opinion will be not very smart, correct, or appropriate, something like that, please? Okay, I understand now. And given that at the position of the civil servant, if we include the position of the judge. I've worked in this sphere for 20 years, and I have always followed all the requirements of the legislation, just like all other civil servants or the people whose job is related to the fulfillment of functions of the state. So regardless of whether I like it or dislike it, we all follow all the requirements of the legislation, that's for sure. And I will follow them.
Ms. Kravchenko, I've looked closely at your motivation like all of my colleagues have. And again, I have a question that concerns your experience. As I read the motivation, I see much there that concerns what you view as lack of access to the court. More staffing is required, more judges are required, more money is required, more access is required. That may be true, but wouldn't a person of greater experience say that better people are required in some respect? You don't really talk much about the caliber, the character, the quality of the applicants who need to be placed on the judiciary of Ukraine. It's all a matter of more money as I read it. Am I reading you incorrectly? Is that an unfair characterization on my part?
In fact, in my motivation letter, I have never mentioned anything about funds and financial support and funding. Maybe that's something incorrect in the translation. In my motivation letter, yes, I mentioned access to justice and professional staff, professional judges, that's for sure. The key focus should be on the professional level of the candidates and their integrity. That's undeniable. It does not mean that we will fill in the vacant positions in the judiciary with people who are just compliant with the criteria. No, the HQCJ has to choose the best out of the best to administer justice. That's undeniable. Maybe that's something wrong with the translation, but I've never mentioned funding in my motivation letter.
You may not mention funding, but you mentioned the kinds of things that require funding: more staffing, more courts, more access, more resources. You may not use the word funding, but you also don't use the word of character. You don't use words of character and the caliber of candidates and the integrity of people and how we need to alter the judiciary in that respect. Is that a problem in Ukraine, that we have people who should be replaced by different people? Or is it just giving them more resources and funding?
No, as I've mentioned earlier, there are two directions on which we should focus. The first one is integrity. Undeniably, that is the demand of the society and the commitment of our state regarding ensuring integrity of judges and candidates, so that worthy persons are holding these positions and unworthy are dismissed. That is the first direction. And of course, that's what I meant when I was talking about the restoration of trust in the judiciary. And the other direction is the selection of professional people, the best of the best, who maybe will replace those people, those judges who will be dismissed.
Again, I don't mean to dwell on this excessively, but you state in your motivation, if the experience of competition shows that they are ineffective, the HQCJ should respond with prompt legislative proposals. Certainly there may be legislative proposals are required, but again, is there not something that the HQCJ needs to do to strengthen the caliber of people who are serving in the judiciary of your country? Is that not one of the important objectives that you must fulfill, that any member of the HQCJ must fulfill? Is it just a matter of more legislative proposals, more spending, more staffing, more resources? Is there not something about the kind of people that have to be chosen to serve in these important positions?
based on the criterion that I mentioned about legislative initiatives that write about the quality of candidates and their selection. If we are talking about the new conditions for the selective procedures, which are in force already. And for example, if we compare them with our former selection or even the selection before that, and that was my goal when I was mentioning legislative changes in my motivation letter, that given the experience that the HQCJ has obtained over 2 years regarding introduction of some additional exams, tests, the necessity, like whether introduction of the exam on the history of Ukrainian statehood, whether it's a sign of professionalism of a candidate. And that's for comparison. Or if we, for example, take into account the procedures that will take place now regarding testing, when candidates are given tests completely and with answers. And when we talk about our previous selection or the selection before ours, then candidates did not have access to answers and questions of tests. And in order to prepare for the exam and pass the exam, it was much more difficult than now. And a person had to study a large scope of information, all the laws from the civil criminal law, because the candidates did not have answers and questions. And only in case of good preparation, you could successfully pass those tests. And in my motivation letter, I meant these additional competitive procedures, whether they are relevant for the determination of this professional element, like introduction of additional exams, their level of 75%, whether it's a decrease of the level or not. That's the analysis I meant. So the HQCJ is the implementer of different legislative provisions regarding competitions. And it may analyze how it works in practice, which outcome will be received, whether the result will be good or no. But the result should, of course, be aimed at identifying and selecting competent judges. And that's why there is the National School of Judges.
One final question, and I'll leave you to my next colleague. Is there a corruption problem on the judiciary of Ukraine? Is there a serious corruption problem on the judiciary on which you're currently serving?
Of course, corruption in the judiciary exists. We are all witnesses of identified facts revealed by law enforcement bodies. So it's impossible to state that there is no corruption. That's undeniable. That's why I will not deny that corruption exists. Yes, it exists, but I'm convinced that right now all bodies and the state do everything possible, implement all possible measures, introduce all possible safeguards to prevent that. There are established bodies, authorities regarding conduct of checks are granted. In its sphere, the HQCJ should also check integrity of candidates who enter the judiciary system. It does not mean that there will be no error, because error always exists. When the candidate applies for the position and when the candidate is being checked, that's one person. The HQCJ cannot check and safeguard the person from possible actions in the future. But in any case, in my personal opinion, right now, public authorities are doing everything possible and improve existing legal procedures so that this is minimized as much as possible, and so that it would not be as critical as it might be happening.
Thank you very much, Judge Kravchenko. Let me return to our chairman, please. Thank you.
Thank you. Yevhen, please, the floor is yours. Thank you, Mr. Chairman. Good afternoon, Madam Yaroslava. I am Mezentsev. I will continue our communication. As a rule, I get the section of questions that are related to the financial situation, property of candidates. So regardless of the fact that our analysts check information about your property and financial situation of the past years, have reached some conclusions, and have received quite exhaustive answers from you. But I still believe that we need to discuss some questions publicly with you so that it would be publicly available. First of all, I would like to ask you about the house that was bought by your close relative, that is by your mother, in April of 2024. There was a comment that she bought a house with an area of 67 square meters in Veliki Krinki village. There was a question from the public and from analysts about the source of origin funds, and you've provided explanation that according to the sale and purchase agreement, this house was bought back in 1993. So in connection with this, I have two questions. Why do we have such a big gap between the acquisition of property and its public registration? 31 years passed since the moment of purchase, or maybe there was some reconstruction done over these years. And of course, please tell us about sources of origin of funds. Yes, this house was bought by my mother in 1993. Reasons why she did not register, unfortunately, are unknown to me. It happens like that. It happened like that, according to her, why she did not register the house for so long. I cannot answer this question, unfortunately. That is, the house constructed in 1989, if I'm not mistaken. There were no improvements or reconstructions made apart from some basic refurnishing. So no investments into this house happened since then. At least from your side. No, from my side, no. Because the house was bought in 1993 and you were born in 1986. So of course you could not contribute to the purchase of this house. Let's continue the topic with Veliki Krinki. Since 2021, you've declared the use of the land plot with the area of 0.21 square meters in this Veliki Krinki. In particular, you declare the house since 2015 on this land plot. Why didn't you declare the grounds of use of this land plot from 2015 to 2019? Probably this question was not asked to me. I cannot check the declarations now that you are referred to, but I can explain about this house. Yes, this is my grandmother's house. That, according to her will, was inherited by me. The land plot under the house is owned by the municipality. The right of ownership for this land plot is not registered, but you're paying rent for this land plot, right? It has been allocated. I cannot tell you for sure. I think I do not pay rent. That's not rent. Then you have the tax, land tax, right? As far as I know, no land tax. Okay, well, let it be. In 2019, based on your declarations, we did not see any bank accounts that you had, and at that time you worked in the National Anti-Corruption Bureau of Ukraine. Can you please tell us why didn't you declare that? Didn't you have any bank accounts in 2019? And how did you receive your salary from the NABU? Again, this question was not asked to me in recent questions either. I had bank accounts. Of course you had them, but because otherwise you could not receive the salary, but you had to declare them. Back then you had to declare numbers. I cannot answer about the explanations or the numbers or about my declaration for 2019 because unfortunately I was not preparing for this question. Okay, the question about vehicle Mercedes-Benz C300 that was bought in 2020 by you. Analysts have paid attention to the fact that you bought it in January of 2020. As of the end of 2019, you had savings in the amount of 380,000 hryvnias, and you bought the car for 403,000 hryvnias. So it was plus 23,000 to your savings. And in connection with this, basically you gave all the money that you had at home to buy this vehicle, because according to our data, this car was bought in the US and it arrived only in April of 2020, and you started repairing it, etc. So my question is the following. What is not the source, but did you give all your money that you had for this vehicle? And during the okay. If I'm more specific, in 2018, I had a vehicle that was stolen. And accordingly, the insurance agreement, I received the insurance payment. Right now, this vehicle is being declared by me all the time because, okay, we are not even talking about that car. We have no questions about that vehicle. No, I'm just talking about the causal link. But how could you pay all of your money for the car? I'm, as the vehicle enthusiast, I understand that it's not just a random vehicle, that's a half sports coupe. And why did you choose this particular car? It's not very practical. Not very practical because I'm on my own and I have only my child. We live together and it was practical for me. That's firstly. Secondly, minimum damages. This car really had minimum damages. Yes, only the front bumper was damaged. Yes. And it was easy to glue it. They were thinking for a long time what to do not to replace it. And from this perspective, I chose it. It had minimum damages and I did not have to bear expenses from the technical perspective. I was talking about the stolen car, and in December, I received the insurance payment in the amount of about 200,000. And those funds that I received for the stolen vehicle were added to the money that I had, and I bought a new car. That's why I'm asking that. According to your declaration, you declared savings in the amount of 380,000 hryvnias, and in January of 2020, that is 1 month later, you paid 403,000 hryvnias. Okay, anyway, let's move on to the question. Let is purely imaginary. As Mr. Ivan, the chairman of the commission, like saying, let's imagine that you are already the member of the HQCJ. The person who is now appointed to this position will have a unique organizational situation because the current commission was selected on June 1st of 2023 in full composition. It worked for half of its term, and it will work for 2 more years, and then its authorities will expire. The person who will join the commission now will become sort of an inheritor, like the legacy bearer of the current HQCJ and the future HQCJ, because it will work for 2 years with this composition of the HQCJ and for 2 years with a new composition. That's a very interesting situation from the organizational perspective. So let's imagine you consider yourself already the member of the HQCJ. Please provide 1-2 significant achievements that you would like to preserve as a tradition for the next HQCJ in 2 years, and what would you introduce in terms of some new developments? Maybe you disagree with some practices that exist in the HQCJ now, and you will be the role model and the most experienced member for the future HQCJ. So what would you do? Please, 1-2 examples. So what would you like to preserve and retain, and what would you change for the new HQCJ?
So, upon your opinion, how you would like for the future HQCJ, I would bring more, how to say it? I would ensure more communication between HQCJ, courts, and the society. That's the first thing. Okay. But what now? What do you think that what is very well is done now that should be preserved, shall not be lost in future, that should be taken as heritage for the future?
Maybe. Yes, it's already happening now. This is a competition for appellate courts. So how it's organized, how the selection procedure is organized for appellate courts, the order, procedure, interviews in chambers, which actually helps to quicken and facilitate the interview process. So this process is very facilitated and logical. Thank you. Thank you, Yaroslava. Chairperson, over to you. Thank you.
Yes. I hope you can hear me. Hello. Good afternoon. My name is Robert Broekhuizen.
Good afternoon.
Yeah, I have not so many questions left because you have been answering lots of questions. The first thing I wanted to discuss with you is the following. I looked at your autobiographic reference, it's called, in my translation. And it says that you have in total 18 years of experience, and you're 39 years old, if I'm not mistaken. That means that you started working when you were 21. That's correct, eh? 20 or 21. Yes. And it also mentions that in the field of law, you have 15 years, 8 months, and 11 days of experience. Is that correct?
Yes, that's correct. I started my working experience when I was 20 years old, when it was the year 2006. When I was 20 years old.
Yeah, and I don't speak Ukrainian, but I tried to look up when you obtained your university degree in law. And if I'm not mistaken, that was in 2008. Yes?
Yes, that's correct.
And if you look at your biography, then first you worked as an assistant in the court and a secretary in the court and the court consultant, and I can see the, let's say, connection with court work. But then you start work for the National Anti-Corruption Bureau. And in my translation, it says that you were the head of the public relations department. Is that correct?
Not correct translation you have. So the position was head of the unit working with witnesses and applicants. Witnesses means those who witnessed criminal offenses, and applicants who submitted applications.
And was this in the public relations department or not?
No, these are different. So in the NABU, there was Directorate of Public External Communications, which were responsible for public communications with mass media and so on regarding functioning of the NABU. And there was also Directorate of Working with the Public. There were two units, and we worked specifically on processing applications. These are two different directorates.
But can you tell me then what the work was that you did when you worked for NABU? What did you do? What was your work?
The directorate which I headed consisted of two units. The first unit was the unit of working with the public. It was responsible specifically for supporting a special hotline on receiving applications regarding committed criminal offenses, and also, according to the law of Ukraine on prevention of corruption, ensured the procedure of receiving applications and inquiries from whistleblowers. There was one more unit, which was called Unit on Working with Witnesses and Applicants. This unit ensured support of the reception desk, where citizens could come with inquiries and applications regarding the committed criminal offenses or without written applications. And then they submitted reports on committed committed criminal offenses, and they received them and processed them. They also processed all other written inquiries, letters, applications, which were submitted to the National Bureau. So it was some kind of primary filter between the main subdivision of detectives and the citizens. So those applications and inquiries were received and processed, part of them forwarded from then to the main unit of detectives, and another part was forwarded to us. Everything related to inquiries from the lawyers, advocates, inquiries for the public information. Is it okay? Do I speak too quickly or not? Do you understand me?
Well, my question to you was, what did you do? What was your work when you worked there? You now explained what the department did, but I would like to know what you did.
So that's what I have done, all the things. So I drafted all templates of all internal procedural documents which were related to functioning of our directorate. So that was my responsibility directly. All replies on behalf of the NABU, including replies of the inquiries received by detectives, involved my work. So I provided drafts of all the replies, or I supported specialists working on those replies, and I also signed all the documents in terms of replies on behalf of the NABU. And I also supported work of the hotline, the reception desk for citizens, and I drafted regulation on the directorate and the rules of procedure, how the directorate works. So I processed all those materials. All replies on behalf of the NABU were provided based on my signature, and further those tasks were delegated to the heads of the units. So that's it. It doesn't mean that I just put signatures. No, I processed all the materials, all the documents.
Mhm. When I read in your motivation letter and I looked what you write about in my translation, what you did with IDLO, the International Development Law Organization. Here it says, in translation of your letter, that you were directly involved in the development of measures to improve communication between civil society and law enforcement agencies. Can you tell us what your work was with IDLO? What did you do? I know what IDLO does, of course, but the question is what you do. What you did what kind of work you did when you worked there.
When I worked at the IDLO, it was lasting during 8 months. I was an expert on the reform of the prosecution authorities. My work desk was located at the office of the Prosecutor General. It means that correspondingly, there was a request submitted to the IDLO from the Office of the Prosecutor General to help with renewal of the public reception desks activities. That's the first thing. And secondly, to support development, the strategy of the in this field of the criminal justice. These were two fields. So the first, the public reception in the Office of the Prosecutor General. What did I do? I drafted the concept, the regulations, terms of reference. I support also selection of staff, and I ensured implementation of the completely new project of a public reception desk, because no other law enforcement authority has had something like this. So there was a fully changed approach for such public reception desk. So any people could come, any citizens could come to this desk in the Office of Prosecutor General to apply human-centered approach, to ensure digital queuing, to increase competences of specialists, to provide feedback and interaction between citizens and the Office of Prosecutor General regarding the services provided. The electronic account of an applicant, as far as I understand, it's not fully completed. So this project, specifically of the electronic account, is still being implemented. So the structure of this directorate has completely changed, and the activities have completely changed. The draft documents of regulations of how this directorate works have been done. That's related to this first field. I'm not going to tell you about repairs of the premises, design, and other things. I think it's not related and it doesn't matter that much. Regarding the second element, the strategy of combating against problems in the field of the criminal justice. After the beginning of the full-scale invasion, the extradition of persons for bringing them to accountability was suspended. One of the reasons, so it's not that suspended, but it was hardly accessible. So one of the reasons was martial law and impossibility to ensure safety and security of persons being extradited to the territory of Ukraine. But there was a second reason also. There were decisions of the European Court of Human Rights which defined that there were tortures, there were cases of tortures in penitentiary system, in penitentiary institutions and the detention centers. That's why one of the reasons to possibility to have this way accessible and to extradite persons to the territories of Ukraine. So there was a need to identify safe and secure detention centers. That's why the strategy of the Cabinet Ministers was approved. The strategy on combating the tortures.
Maybe can be a bit shorter, because I didn't ask you to explain everything what happens there. I only asked you to explain what you did.
So yeah, I explain. That's what I was involved. I drafted all the documents.
It's clear to me. It's clear to me what you did, and thank you for the explanation. And I don't want to be difficult, but the only reason I ask it is that when I read your resume, I was considering what your work between 2014 and 2024, what kind of connection was there with the judiciary? And when I read it, my conclusion was there was no relation between your work then and what happened in the judiciary.
Can I reply?
Sure.
Yeah, of course, I didn't administer justice, that's for sure. But at the same time, I can't say that it was not completely related to the lawmaking and legal experience, legal work. Any field of activities was completely connected with application legislation. Of course, it's not about administering justice. I would not say things like this, but I don't agree with you. All my activities starting 2016, it's not 2014, actually, 2016. So I quitted the job at the court in 2016. So all my work since 2016 to 2024, it was legal work, legal experience.
Right. Okay, but it was legal work, but we agree it had no direct connection with what happens in the judiciary. Being a prosecutor, I've been judging, I've done anything. I always say to people that it takes at least 10 years before you're a proper lawyer or someone who can write good judgments, or being a good advocate, or being a good prosecutor. It takes time because it's a difficult job. And or don't you agree with me that it is a difficult job to being a judge, and that you need to learn it?
Regarding 20 years, from one perspective, yeah, I agree with you, of course, but from another perspective, yes, there are so many different examples where sometimes when a person has 20 years of experience, it doesn't mean that this person is indeed a good professional at their field. Cases could be different. And I have enough experience, working experience, I mean, generally, to feel that I'm on the relevant professional level. From the judiciary perspective, yeah, indeed, I do not object that I have been working as only for a year in the position of a judge specifically, but I can't say that it's just a little time. During working at the position of a judge, you should understand that you always have some other things or other causes, other situations which have never been before, other tasks, maybe in another different local court where the workload is much less. They do not consider cases which are considered by judges in the Kyiv courts. So yeah, I agree with you that I have only 1 year of experience, but at the same time, I think that my professional level is enough to work in the High Qualification Commission of Judges. That's why I'm not going to argue with you regarding this short period of time as a judge. I tried to show you as much as possible my professional level and my professional experience, what they were about.
And that is much appreciated, of course, that you explained that to me, but I'm here to ask you critical questions. And the critical question, of course, I have to you is that I see a lady of 39 years old, where I see that you've, before the 1 year that you were a judge, for quite some time, you have to be doing something different, which I think, but maybe I'm wrong, has to do something with communication. And your communication skills are clearly very good. However, being a judge, or in any case, it has nothing to do with judging. And I think that you're a good communicator, but my idea is that after 1 year, you cannot say yet that you're a really experienced judge and that you have seen the in and the outside of the judiciary. And of course, if that's the conclusion, then the next question is, why would you be appointed in the HQCJ? And the question I have there is, to be a member of the HQCJ, you have to be able not only to study the documents, but also to interview people and to judge and to see whether those people you interview and you have to take decisions on, they comply with the rules that are applicable in Ukraine, that someone can be a judge, because that's in the HQCJ, the decisions are taken whether someone can be a judge or he cannot be a judge, or whether he can be selected for the High Anti-Corruption Court or the High whatever court or the Supreme Court. And that's something that you have to decide. So the question to you is, why do you think that you have skills to select people, for instance, that will be judged in the Supreme Court, if you yourself only have been 1 year a judge in a lower court? Why do you think that you have this ability to do that?
Firstly, the HQCJ, members of the HQCJ evaluate candidates, in my opinion, based on existing regulations, procedures, and clearly established rules. So, conduct of the interview and qualification evaluation take place in line with the adopted rules and current legislation, including qualification exams. While being take into account my insignificant experience at the position of the judge of the local general court, it's obvious that if we take about me here, this position, I cannot assess decisions of the Supreme Court that are adopted by justices of the Supreme Court. At the same time, Qualification Commission of Judges is selecting candidates based on the application of all established rules, methods, methodologies, their compliance, their improvement maybe in the process of competitions, among other things, as well as a check of people in terms of integrity. And I believe that my experience, including at the position of the judge, allows me to do that with high quality. And maybe to suggest some initiatives and maybe to prove to members of the HQCJ that it is necessary to implement these initiatives or the absence of such need. Let's put it that way.
Okay. The point is that part of the work you have to do and is that people in the HQCJ, for instance, interview people. And after they have interviewed, they discuss among themselves whether the candidate is suitable for the job it applies, or he or she applied for. Yes? And interviewing a candidate and judging whether someone is suitable is something that you cannot do just because you have the obligation to do it. It's also something you, I guess, need to learn. You have experience in interviewing people and making decisions on those people when they apply for a job.
Yes, as I've mentioned, I have experience for about 5 years in the National Anti-Corruption Bureau. I was the deputy chairperson of one of the selection commissions out of the 3 commissions which we had in the NABU with respect to the selection of candidates for different directions. And since the NABU was only established back then, we had lots of competitions during these 5 years. As I mentioned previously, in some cases, we had 250 and 100 persons for one vacant position during the competition. We had such a competition. So of course I have experience for quite a significant period of time. That's about 5 years. And I was participating in the selection of candidates for positions in the NABU in cooperation with the representatives of the Public Oversight Council, who were also members of these selection commissions. We were selecting these candidates and we were interviewing these candidates. And yes, of course, I do have this experience.
Well, I'm happy that you have, because that would be beneficial, of course, if you would be selected in the HQCJ. Can you tell me, if there's a candidate, what you would ask the individual to identify if someone can be trusted or he cannot be trusted? What kind of question would you ask, for instance, to me, if I would be applying to be a judge in Ukraine, to judge whether I'm someone who has the background and the ability to become a judge, and whether I'm honest and truthful, and etc. Is there any question that you will always ask, or?
To candidates, it's necessary to take into consideration that the HQCJ has the procedure and the criteria based on which questions are asked. So if we talk just about the conduct of interview and determination of honesty of the person, so of course we need to conduct analysis of some instances maybe during the life of the candidate and to ask about some specific situation from his or her life. I think that based on answers of the person, it is obvious whether the person is honest, because honest people sometimes say some unpleasant for them things, unpleasant for them or for surrounding people, or which show themselves as a personality. A dishonest person may not answer questions regarding some specific situations. And they may answer, but it will take a long time. It will be very ambiguous in response to follow-up questions. Candidates get lost. And when, for example, there is any situation, for example, bringing to administrative responsibility. And when the person, instead of recognizing this and admitting that, yes, it did take place, yes, I reached some conclusions for myself, it happened because of this and this. Like when this person is honest, then the person says that. And when the person is dishonest or cannot accept the consequences of actions, they will start saying that it happened because the police officer was wrong. I challenged the decision with the court. The court denied, for example, because, and that's it, etc.
Okay, thank you for your answers. And sorry that I've been pressing you a bit. And I please give the floor back to our chairman, Mr. Mishenko. Yes, Ivan.
Colleagues, our interview is already over 1.5 hours long. Do you have any other questions to Madam Yaroslava, or are we going to finish this interview now? No, I do not have questions. Yevhen doesn't have questions, right?
No questions.
Okay, thank you, colleagues. If you do not have any other questions, then Madam Yaroslava, now you have the opportunity to summarize our conversation today. What you would like to say while addressing the selection commission. Please, the floor is yours. First of all, thank you so much for the opportunity to participate in the interview for the position of the member of the HQCJ. I've tried during this period of time, maybe I was nervous a bit, I'm sorry. I've tried to tell exhaustively about my motivation, about my experience that can be useful in my opinion. That's why I'm sincerely grateful to you for the conducted interview. And that's it. We are also grateful to you, Madam Yaroslava. And we wish you all possible successes. Now I consider the interview to be over. Thank you. Thank you, colleagues who have been watching us. Now we can suspend the broadcast.
Шановні колеги, ми
So,
онлайн.
dear colleagues, we are online.
Конкурсна комісія
The
продовжує свою
Competition
роботу
Commission continues its work
конкурсу з добору
on the selection
на
procedure
вакантне місце члена
for a
Вищої
vacant
кваліфікаційної
position of
комісії суддів України
HQCJ
по
member
квоті суддів
of
або
Ukraine under the
суддів
quota
у
of
відставці.
judges or retired
Наш
judges.
кандидат
Our
Вознюк
candidate
Оксана
is
Леонідівна.
Oksana
Вітаємо
Leonidovna
вас, Оксана
Voznuk.
Леонідівна.
Greetings, Oksana
Співбесіду
Leonidovna.
проводить комісія в
And
повному
this is the
складі.
Competition Commission in its full
Я
composition.
Іван Міщенко і
My
мої
name is
колеги
Ivan
Євген
Mishchenko and
Мезенцев,
my colleagues
Терзажечний,
Yevgen
Сергій
Mezentsev,
Варламов,
Terzazhechny,
Роберт
Sergei Varlanov,
Брукхайзен і
Robert
Стівен
Brookhuizen,
Баркман.
and Steven Barkman. Good evening.
Дуже добрий вечір.
Yeah,
У
good
когось і
evening.
ранок,
Yeah,
Оксана
for someone, it's actually good morning.
Я дуже коротко
So,
вас представлю,
I
після
will
чого надам
introduce
вам
you very concisely, and then I will give you a floor to be also concise, wrapping up and telling us why did you decide to participate in this competition and what do you see as your advantages, as your strong sides as a candidate for this position of HQCJ member. Just to inform our audience that there could be some problems with internet connection from the side of the candidate, and maybe from time to time your video will be turned on or off. And it's caused, it could, if it happens, it would be caused by the problems with internet connection. So we will take it into consideration. Oksana Leonidovna works as a judge in the Bilotsarkivsky sitting district court in the Kiev region. Before it, she worked as a judge assistant at the High Anti-Corruption Court. Before it, she worked as legal advisor and assistant to legal advisor. Her general legal experience is 18 years old, and her experience as a judge is a little bit less than a year, almost a year. So, Oksana Leonidovna, over to you. Thank you. Thank you, dear members of this commission, for this opportunity to join this competition, to present myself, to introduce myself and present maybe some kind of my ideas and my vision. So speaking about me, my professional experience counts almost 20 years because I have started working in the legal field when I was still a student of the legal department. And I started from the private legal sector, and then I moved into the public legal sector. Speaking about beginning of my career, it was related to the private law. Mainly, it was about provision of support to businesses and representation of interests of clients in different court authorities. I was not that much involved into civilian cases. Mainly, I was involved into commercial cases and administrative cases, including those related to tax disputes. This was one of my specializations. And specifically, this participation in court trials of administrative jurisdiction gave me motivation some time ago to participate in the position, in the competition for the position of a judge. Because, yeah, frankly speaking, I saw some things which I was not glad to see in the judiciary system. And I'm the kind of a person who thinks that if you want to have something better, you shall show it with your example, or you shall do it by yourself. So after the competition procedure, when I participated in the competition procedure, I passed exams and I had a 9 months learning period in the School of Judges. I have also passed qualification exam. And all of us, we know that there was a pause in functioning of the HQCJ. During that pause, I had an opportunity when I received an invitation of one of the judges of the High Anti-Corruption Court. So they invited me to join their team, and it means that for 4.5 years, I had worked as an assistant judge at the HACC court. That was actually my former position before I was appointed as a judge of the local court. This is in a nutshell about my professional path. And also now, I'm getting academic degree of the Doctor of Philosophy in the legal field. I have already completed my dissertation research. It was already published and it's recommended for the defense. And the academic council has already approved it. And in a month, roughly, there will be a public defense of my dissertation. And the topic of it is abuses of procedural rights in criminal proceedings. That's the title of my dissertation. And also, a part of these activities, I am current lecturer of the National School of Judges, and I have this honor to contribute to drafting trainings and to provide those trainings to participants, to the audience. Among topics which I teach, I have integrity in professional activities of the apparatus of a court. I also train on the topics of how to build an efficient team of an assistant, secretary, and a judge. And I think one more training, that's opportunities for career development. These are specifically those topics of trainings which are connected to the judiciary career and where I have indeed an opportunity to communicate with the apparatus of a court. And apparatus of a court is also a component of the judiciary, and actually it presents the very face of the judiciary system. So in practice, we have this opportunity to consider different situational tasks, so practical tasks, and to look at them, how employees, how the staff of court behaves in different situations where there could be conflict of interest. It's actually quite an interesting topic. I like so much to teach adults, and education for adults is so interesting because when you prepare, when you draft some workshops, some trainings, you also deepen your knowledge. You also deepen your knowledge in this specific topic and you increase your professional level. It also allows to discuss with your colleagues some acute problems which are are now on the table. Specifically, all these my activities motivated me to participate in the competition for the position of this vacant position. And I think that the Commission knows that that's my second attempt in this competition. And for myself, I see that my task is the following: not only to assess and evaluate candidates for the positions of judges in this field, but I would like also to help create those conditions for the judiciary when not just sporadic persons come into the judiciary system, but no, when professionals, really professionals with integrity, with high level professionalism come into the judiciary. And I think that the experience which I have, the skills of result orientedness, the skills of processing huge volumes of information and of making motivated decisions within limited time, all this will help me to to strengthen the current wonderful composition of the HQCJ members, which we are having right now.
Thank you very much, Ms. Oksana, for such a justified and systematic introduction. You are a very developed person, so to speak. I will start the Q&A session. When you used to work in the private sector, do you used to be a lawyer? No. At that time, the lawyers' monopoly was not very well widespread. I was just a sole trader and I provided the respective legal services by representing interests of the parties. So you represented the interests of persons. Yes, it is just the same as working as a lawyer, but I was not registered as a lawyer. Yes, thank you. I know what you're talking about. You said that you want to do something good. And if you want to do something good, you need to do it yourself. If you want to see some improvements, start with yourself. What are you not happy with in the judicial system, and what do you want to improve in the first place? If we speak about the current state of the judiciary, I see two main directions we need to improve. The first one is the communication of courts and civil society, and also the transparency and open registry. We need to do a lot of work with the civil society. We have such a low level of trust of civil society to the judiciary. Many people do not understand what court is doing and what is happening inside the court. Yes, we know there is a court, they make decisions, and they assess the activity of the court only using the information flow they have access to. And sometimes, unfortunately, this information flow is negative. I will give you an example. For example, we have in use that some person was dismissed, or he was released on bail. And ordinary people think that a person paid a bribe for being released. So paid bribe somebody, and that's why this person was released. And we need to clarify to civil society what a restrictive measure is, that this restrictive measure does not define whether the person is sentenced or accused or suspected, and we need to go through the procedures. Another point I would like to raise today is to bring in the judiciary practice and to align this judiciary practice. We don't have plenums inside the judiciary. In the past, this plenary was born by processing a big number of rulings, decisions, by revealing different challenges, problems, shortcomings, giving explanations how judge should act in this or that situation. Unfortunately, today we don't have this instrument. These overviews and reports, which are being done by the Supreme Court, exist, but unfortunately, they are not comprehensive like they used to be. And that gives birth to different practices within different courts, both of the first instance, courts of appeal, cassation courts. Apart from that, we lack a mechanism where we can generalize different shortcomings which do not go to the cassation court. Some of them stop at the level of appeal stage. In its turn, that causes a low level of trust from professionals, experts. Because when a lawyer or a prosecutor comes to a trial, do not have an opportunity to calculate the expected result. He or she doesn't know what to do and how to act in different situations. Thank you, Oksana. Let me stop you here. Thank you for answering my question. So the reality is, and I believe that the practice of plenum of the Supreme Court, unfortunately, is not likely to happen in the near future. And I'm afraid we're not coming back to this practice at all. We see that the trials became more complicated, and it is very difficult to summarize them and to build one algorithm and to advise how you should act in this or that situation. Given that there will be no plenums in the future, what will be your potential role in the HQCJ and how to resolve this problem, in your opinion? Like you explained to us, this problem sounds a little bit you know, unresolved, and it is impossible to resolve up to you. So if we don't have any plenums, how the lawyers will apply the positions, the rulings, the decisions which exist? And sometimes it seems that these decisions contradict each other, but we all think and we believe they do not. But still, we would like to hear your opinion on that. We have such a wonderful mechanism as the National School of Judges, and the HQCJ has a certain influence as to the direction where this National School of Judges should move. I'm being as a lecturer and as a user of the services of the National School of Judges because I'm training there, I'm being trained there. It seems to me that very often we don't have the combination of theory and practice. Let me give you an example. The School of Judges very often invites wonderful academics who give a lot of interesting information. But in my opinion, we need to invite the practical judges, for instance, for them to share with the shortcomings, with the challenges that the judges come across during the trials in their court practices and what to pay attention at. And I think such combination will be effective. Along with that, it will be very effective when we have a dialogue between the first instance court and the cassation. I think it is the best practice that exists today. And HQCJ in this sphere has some influence on the School of Judges. Thank you, it's clear. I have another question and then I will give floor to my colleagues. Miss Oksana, there is an opinion that there are a lot of competitions within the judiciary. The judges for the first instance court, appeal courts, and I hope for the cassation courts sooner or later, but we will have them. But there is a thought that we are lacking good candidates for these competitions. And we also have problems with those willing to participate in the competitions. Along with that, when these competitions start, we come across the situation that the major part of candidates do not overcome the barriers which are stipulated by the competition procedures. And the closer we come to the final stages, we understand that we have just two candidates for the position for the final interview. So my question is, do you have any ideas as to this problem? And how would you suggest to encourage the representatives from legal field, lawyers, to apply for such competitions and become judges? And why, in your opinion, there are less those willing to participate in the competitions? Well, speaking about your first question, if we are talking about the competition for the first instance courts, if it was successful on the stage of application, and we actually have a lot of willing candidates to go along this procedure. Speaking about the appellate courts, here, the attention to the private life plays a big role, and many lawyers are concerned that somebody will intrude into their private life and they will be requested to explain some uncomfortable things. You ask me how to change it. Well, my suggestion is we need to inform the civil society that the access to this certain level of the private life is a standard. And the Integrity Council is not an evil in its nature. It's the voice of society, and we need to respond. I think it's a question of communication, in fact. We need to give clarifications to our potential candidates that you will not be blamed in any crimes or violations. But if civil society has reasonable doubts as to your certain conduct or property situation or the way of life, then please give explanations from your side. Nobody will prosecute you, and it's absolutely normal to give explanations about your life. I have provided explanations several times as to my private life. We all need to understand that all concerns expressed by the civil society are very well explained by the candidate as to the private life. And also the explanation as for the High Anti-Corruption Court and the candidates not willing to apply to the competitions. I think not much depends on the HQCJ, but of course, the HQCJ can express their opinion, which is need to expand the requirements to the competition. In my opinion, when this institution was created, there was a need to create very strict limitations and set very strict restrictions, so to speak. But now time has passed, and we have established a lot of notorious persons who were excluded from the judiciary, from the law enforcement bodies. And thus now we can a little bit ease the access to this position, and I think that will increase the number of candidates. Thank you, Oksana, for your answers, and now I would like to give floor to Ted. He will ask some questions to you.
Yes, thank you, Mr. Chairman, and good afternoon. Perhaps it's evening for you. It's morning for me. I am reminded as we go through this process, and I think you will be aware as well that at the HQCJ, you will have to do work much like we are doing with you right now. And that is to conduct an interview and to have the opportunity to give you the opportunity to explain to us the kinds of issues that we have to assess you as a candidate. I was very interested in a comment that you made in your motivation letter, and let me read it to you. You say, both in the competitions to the cassation instance and to the higher specialized courts, and in the qualification assessment, many candidates are selected based on the results of an interview that contains subjective judgments. Now, that is what we're doing right now. We're interviewing you. Now, with the development of artificial intelligence, I suppose that we could come to the time when all of the ingredients of a candidate, a perfect candidate for the HQCJ, could be fed into the AI resource, and they would simply, the AI would choose the candidate to be appointed to the HQCJ. So we wouldn't need members of HQCJ. The same thing could be said of the appointment of judges. We'll just simply let the AI look after that business. my point is this, in this clumsy illustration that I'm giving you. What role do you think there is for individuals, human beings, members of the HQCJ? What role do you see humans like us contributing to the process of selecting judges?
На мою думку, члени ВККС
In my
як
opinion,
люди
the human members of HQCJ have more attention to analytics, facts, statistics, while evaluating these or that candidates, and they apply their human approach to this assessment as well. They do not stop on the formalities, the lack of cancelled decisions or challenged decisions, the number of disciplinary sanctions. They are able to analyze comprehensively. As an example, if a judge has a number of rulings cancelled, only a human can look into it and decide why it happened, whether it was a shortcoming of this judge, or maybe it was an attempt to approve a non-standard decision in a particular situation. Or, for example, if there are no complaints from the IHQ, from the High Council of Justice, and it can speak that the person avoids taking difficult decisions, or probably the decisions are perfect, and he could consider even sensitive cases. That's why I think that artificial intelligence at this stage and in this sphere cannot replace a human being.
I see. You're speaking about judgment, of course, and machines will have difficulty, I think, exercising judgment. But my point is, you seem to discard in the process the value of interviews. And of course, the HQCJ conducts interviews of virtually every candidate for every position, whether it is a first position as a judge of the first instance or a position in the appellate or Supreme Court. So what role do you see or value do you see from personal interviews?
Я поясню трошечки,
I will
що я
explain a
маю на
bit
увазі
what I meant
спочатку
in my
у
motivation
своєму
letter
виступі, коли я казала
when I
про
was talking about this
надмірний
excessive
суб'єктивний фактор.
subjective factor.
До прикладу, на
For
сьогодні
example,
ми
nowadays
маємо
we have
певний набір компетентностей,
some
які
sets of
оцінюються
competencies
членом
that are
ВККС
being
при
evaluated by the member
кваліфікаційному
of the
оцінюванні
HQCJ
кандидата або ж
during
судді.
qualification evaluation of the
І
judge
кожна
or
з
candidate. And
компетентностей
each of the
має
competencies
максимальний
has
бал.
the
До
maximum
прикладу,
score.
візьмемо
For example,
компетентність
let's
професійного
talk
розвитку
about such
кандидата.
competence as professional
І
development of a
я
candidate.
в своєму мотиваційному
And in my
листі мала
motivation
на
letter,
увазі,
I
що
meant
кандидати
that
до того, як
candidates,
вони будуть подаватися
before
до
they
практики,
apply for
мають
some
розуміти,
competition,
як
have to
саме цей
understand
критерій
how this
оцінюється.
particular
Тобто,
criterion
що
is going to
саме
be
ми
evaluated.
вкладаємо в достатньо
What in
професійний
particular we
розвиток.
mean when we are
Чи
talking
це
about sufficient professional
буде
development, whether it
один
will
раз
be
на рік
like
проведено якесь навчання
some
чи досвід,
training only
чи
once per
це
year,
буде
whether it will
певний
be
курс.
enough, or maybe
І
there should be a specific number of
я до
trainings.
того, що комісія,
And
приймаючи
I
рішення,
mean that while
має
taking the decisions, Commission
пояснювати,
has to explain
чому саме
why, in
виставлений
particular,
такий
they
бал за
put the particular
компетентність.
points
До
for this
прикладу,
competence. assessment. For example, the same check of practical assignments is also performed by human beings. These are not only interviews. We also have the human factor in this element. For example, the situation with the ongoing competition.
Excuse me, I'm going to interrupt you because I think you're straying away from my question. My question is a simple question. What role do you believe should appropriately be played by the personal interview of candidates?
In my opinion, interviews should establish motivation of the person, why this person is applying, what motives the person has. Secondly, with the help of interviews, it is possible to create some case studies and to find out how the person is going to act in a specific situation. And besides, interviews always reveal the sincerity of the person, whether the person is sincere in giving answers, and it also shows the attitude of the person towards their action. Because in my opinion, when we are assessing integrity of the person, that's not only about how the person acted, but also about the self-evaluation of that action. And that self-assessment of this action can be clarified, in my opinion, only during personal communication with the candidate and by means of asking questions and receiving answers.
Thank you. My last question is deals with your experience. We might very obviously be concerned that you have only 1 year experience as a judge. Having said that, you have, of course, 4 years or thereabouts experience as an assistant to the judge at the High Anti-Corruption Court. What similarities have you experienced now between the role and function of an assistant judge to a judge and a judge? And what do you say about giving you credit in terms of assessing your qualification for the period that you were an assistant judge? So what are the similarities between that role and your role now as a judge?
First of all, that's the processing of the case itself. That is being done initially by the judge assistant, and then the judge starts doing that. Before I personally go out into the court hearing, I have to get acquainted with the case and to study the materials of the case. Of course, during the court hearing, the judge has more functions because the judge is the one who has the opportunity to communicate with the parties directly and to clarify some circumstances and facts while resolving the case. But if we talk specifically about my experience, then the peculiarity of the High Anti-Corruption Court consists in the fact that assistants of judges also attend court hearings in that court. And basically, they listen to explanations of the parties, and they have the possibility then to express their vision of this legal situation that was presented. So that's why this experience has been really helpful for me when I became the judge, because I understood what I should pay attention to during the court hearing.
Thank you. Thank you, Mr. Chairman. Those are my questions for the present.
Дякую, Тед.
Thank you,
Будь
Ted.
ласка, Сергій.
Please, Sergey, the floor is yours.
Мікрофон, будь ласка.
Mic, please. Switch on your mic. Madam Oksana, in continuation of the questions that have already been asked by Ted, I have the following question now. As you've explained, you are the instructor in the National School of Judges of Ukraine right now. As far as I understand, after appointment to the position of the judge, you've become the lecturer. No, before that. When I was working as the assistant of the judge, then the National School of Judges was inviting me to give lectures and was involving me. Okay, clear, thank you. In your opinion, is it necessary to change approaches? And here I would like to clarify, are you teaching to candidates or to sitting judges? Right now, my key category is the court apparatus, assistants. Yes, okay, thank you. Can you please tell me, in your opinion, given that you have been the trainer in the National School of Judges for a long time, is it necessary to change approaches to professional training of judges? I have mentioned a bit about involvement, like deepening of involvement. Are you asking about sitting judges or just... No, I'm asking about candidates for positions of judges. Okay. Here I have the experience of studying in International School of Judges for 9 months as the candidate. And right
Вона замінена на двомісячне навчання після призначення особи на посаду судді. І, як на мене, це теж дуже велике досягнення діючої ВККС.
HQCJ, because I think that it was thanks to their initiative and thanks to their initiative. Why? Because those 9 months that we were studying for were excessive, spending of resources and time. We were studying all 4 jurisdictions, and most of us did not need that information. In turn, currently, these 2 months of the training that are offered are completely enough, in my opinion. But I would add, as a young judge and as while communicating with my colleagues who are young judges, in addition to practical knowledge, or trainings or workshops, it's necessary to add some organizational ones. We need to understand that judges, especially judges of the first instance, are persons who have never had previously any experience of working in judicial bodies. And they do not know about organizational issues. For example, how to work with databases, how to ensure a workflow in the court, how that is happening. And in my opinion, that should be added to this initial training. Okay, thank you, Madam Oksana. Can you please tell me, given that in your speech, you mentioned that you want to help to create conditions so that judges with integrity and professionals come to the system as kind of a motivation for your participation in this competition for the position of the member of the HQCJ. How do you see your role as the member of the HQCJ? My role as the person who, according to my subjective opinion, has skills of communication with people. I have some communication of evaluation, because what I forgot to mention in my introductory speech is that I'm often involved into legal awareness raising events. And I'm also invited to some organizations to conduct moot courts, Olympiads, where we provide some evaluation, where we listen to young lawyers. And these skills of legal awareness raising, skills of communication with people, skills to see their motives, their behavioral competences, I think I can strengthen in such a way the Commission. Besides, nowadays we see that members of the Commission face excessive workload, and in my opinion, absence of even one member significantly impacts the work of the Commission, its speed of processing of those procedures. Okay, do you have experience of communication with people and evaluation, and that's why you believe that your role will be useful in this Commission? Okay, clear. What would you like to add to what exists? I believe that the Commission could use the Public Integrity Council more effectively, in fact, because it's not necessary to perceive the opinions prepared by the PIC as something, as the intent to undermine judges or to undervalue someone. It should be perceived as a tool for determination of the integrity of the person. And what should be done for that? What do you suggest? What do you suggest to do that? To have more constructive dialogue with the Commission, not perceive it, not the Commission, but the Council, not to resist it, but on the contrary, to divide the duties, and to suggest to PAC, please provide us with this and this and this information, and it will facilitate and speed up all of our processes. Okay, clear. At the very beginning of your speech, you said that while being the representative of the court, you saw moments that you were dissatisfied with, in particular in the judiciary. Can you explain which moments were you referring to? And do they exist today? They do not exist today. Just a specific example that I would like to provide, which became, in my opinion, the breaking point when I decided for myself that I should join the judiciary. I had tax disputes in my proceeding with respect to the same economic entity, but for different taxation periods. And the court of the first instance adopted completely opposite decisions. For example, we were happy with one and not happy with the other one. But the legal relations were the same. We go to the Court of Appeal. The Court of Appeal supported both decisions. Back then, there existed the Higher Taxation Court. We filed our claims there, and it also upheld those decisions. And what I didn't like, when I submitted the case for the review to the Supreme Court, because in the same cases we had two opposite decisions. As you remember, it was going for the Cassation Court, and the Cassation Court did not submit this case to the Supreme Court, and they just responded that these were very different legal relations. And back then I was furious. It should not happen like that, and judges should study those cases in more depth. Okay, thank you, Madam Oksana. That's the end of my questions, and now I'm passing the floor to the chair, Ben. Thank you. I'm passing the floor to the member of the commission, Stephen Markman. Stephen, please, the floor is yours.
Thank you very much, and thank you, Judge, for appearing here today, for your thoughts, and for your past work on the High Anti-Corruption Court. We all appreciate that history. You say in your motivation, Judge, I have always found it important to go along with my colleagues. Well, that's good. That makes for a pleasant working relationship. It shows a certain level of cooperativeness, but it doesn't say much about your sense of independence and leadership among the 16 members of the High Qualification Commission. We have 16 members on that commission, and they have an extraordinarily important role for the future of judicial reform in your country. And we have one of the 16 members saying it is important to go along with my colleagues. You then say that as an assistant judge, you try to do certain things that would put pressure on other people to go in the right direction. But you don't say anywhere that you ever spoke out clearly and said, this is what we should do, and this is how we should do it. It sounds to me like you're speaking the language of the assistant judge here. I've always found it important to go along with my colleagues. Well, let me ask you, what do you add to the commission if that's your role? You've got 16 members of the commission, and you have found it important to go along with your colleagues, and that's good. I think all of the 6 of us try to go along with our colleagues too, where we can. But I think if you asked any of us what our role was on the commission, we would probably add something much more to our role than simply that. What do you add to the commission by playing that role?
This common ground, in my opinion, does not only not to cause pressure in the context of the motivation lab, but there was the focus on pressure, on the absence of trust and judge. If we're talking about some equality between colleagues, as is happening, for example, right now, when judges at the first instance also have the opportunity to hear cases in panel L3. I have this experience, and we also accordingly find some solutions. And among 16 members of the HQCJ, the common ground means, as I understand this notion, it means that there should be constructive dialogue. It is not necessary to perceive the opinion of a colleague, even if you do not like it, something hostile. If you disagree with opinion, then I believe you have to explain why you disagree with it, and you have to provide your arguments. For me, this is when I talk about common ground. When people and colleagues, members of the commission, have a constructive dialogue. In case there is some disagreement or some different views on some specific issue.
You're providing leadership for the country, the entirety of Ukraine, in transforming its judiciary. Do you think that attitude is the kind of attitude that would be supportive of a larger cause of judicial reform? You're prepared to speak out in favor of your positions?
Я вважаю,
specifically Dutch approach, such an attitude will be more efficient in implementing judicial reforms because as a result of such dialogue, we will be able to make a correct decision and introduce mechanisms and processes which the judiciary reform requires. Along with that, if the Commission actually enters into the conflict, in my opinion, it will lose its scope, the important mission that they perform.
Well, I think it's clear they don't have much experience. That's noted, and I don't think you should agree with that. Not had much experience as a judge. But I don't think that's that's the end of the analysis. I think if there was some indication or motivation that brings some fresh and innovative perspectives, some new perspectives to the work of the Commission, to the cause of judicial reform in Ukraine, I think that would be important to know, because it's not your experience that you can that will allow you to offer a great deal. It has to be your ideas. And as I look through your motivations, I'm having a hard time understanding what you consider to be the critical reforms that are going to be necessary to strengthen your country's judiciary. What are your fresh ideas? What are your innovative and creative perspectives as somebody who can't bring experience, but may be able to bring something else to the role of a member of the Commission?
Regarding my vision, regarding what I can offer in terms of something new, or based on my vision, my position. So first of all, during assessment of candidates or the qualification assessments of judges, part of those competences that we already have on the assessment, I think that it would be needed to take into consideration, so to say, reputational resilience. So what I mean here, I was following. To which extent for a person a role which he or she performs in society is important, or which he or she is plans to perform. How does he respond to critics? For example, if we have some kind of a piece of negative publication regarding this person in mass media, how this person reacted to this critical publication? And we should also clarify what are their thoughts regarding this critical publication. To my opinion, I think that this is one of the competences that could be included into the assessment and take it into consideration when the opinion regarding the candidate is being made.
You're an intelligent and articulate individual. You've looked at least as many records of public attitudes toward the judiciary as I have. I mean, I've looked at the polls, and I looked at public opinion, and I looked at dissatisfaction by many people of Ukraine with the judiciary. What are the larger problems with the judiciary of Ukraine? What is the great work that you have to do on this HQCJ to make the judiciary of Ukraine a better judiciary than it is? Is it dialogue? What is it? What are you committed to doing to transforming the judiciary of Ukraine and elevating it to the highest standards of Europe so that it can compete in that world? It can distinguish itself in that world. What are you going to do? What are you as a judge going to leave as your legacy on this court? I'm sorry, in this commission.
In my opinion, the commission and I, if I'm going to be the member of this commission, so in order to increase the level of public trust, we shall hear what the public says. Yes, indeed, I think that the dialogue and transparency is crucial for the public in terms of activities of the commission. We shall not just study the opinions and conclusions provided to us by the Public Integrity Council, but if we think that there are substantiated doubts raised by the public are not actually proved, and then the decision made there, it should reflect our and the motive, the substantiation of the decision made by the Commission shall include all issues of concern raised by the public. It will all help and that's my opinion, I'm sure that will all help to increase the level of trust of the public, because it will show to them that we have heard them, we have responded to their concerns, we have taken them into consideration, and and that only professionals and people credited with integrity are actually allowed access to the judiciary system.
Are those many Ukrainians who don't have trust in the new Ukraine, are they misunderstanding things, or do they understand things correctly in your judgment?
Я думаю, тут
Here again, it's not related to the work of the commission. Maybe it's more about communication directly of the judiciary with the public. Unfortunately, we don't have a very high level of performance of the services of courts or judges' speakers. I will give you an example based on my own experience. For example, my colleague has made a decision in a court case regarding a car accident where a person died, in which person died, and defendant actually received a conditional punishment here, and the public actually outburst and anger because there was a death of a person because of this car accident. And actually, but they thought that the level of punishment was not severe enough. And here, the judiciary should actually contribute and to explain that there is an opinion of a victim, that there is a position of the prosecutor, and to explain to the public that actually, as of now, a judge more performs a role of arbiter, and who makes actually a decision on for the benefit of that party to the process, who provided more evidences.
As I look at the report that I've been provided you, and I don't mean to be difficult with you, I'm just trying to understand what you can add to this commission. That's what I'm trying to find about from all of the candidates, including yourselves. But as I read the report, you've had a very brief tenure, of course, on the court, and it's stated that you have failed to satisfy many of your filing deadlines. Why hasn't this been more important to you as a new member of the court? If I was a new member of the court, at least for the first couple of years, I would do everything I could to try to show my colleagues and show the public that I'm going to be the best judge I can possibly be. But it seems like you have failed to meet a lot of the deadlines you're obliged to meet. And isn't this one of the small things that the people have come to distrust about the Ukrainian judiciary, or at least some members of that judiciary?
А чи можу я прояснити, про які
Can I
дедлайни?
explain what deadlines you're talking about?
This was a summary statement that was made by people who were looking at the details of your cases. They didn't identify all the cases, but they said it was characteristic of some of your decision making that you were not living up to the filing deadlines that you had. You don't recall those?
Ну, я можу згадати
I
лише
can recall only in the context of cases on administrative offenses, maybe, because there we have only 15 days for consideration of those cases, and usually persons are just can't make it to prepare themselves for consideration of their case within 15 days, and they ask to postpone those hearings. But regarding the deadlines of bringing to responsibility those persons, as far as I remember, I always met those deadlines. Regarding criminal cases, yeah, actually, I'm very sensitive regarding meeting deadlines in criminal cases, and that's why I cannot recall in my memory for me as an investigative judge that I allowed myself to violate any deadlines.
maybe before my next question, I'll be able to lay a better foundation for that question. And if it's so, I'll ask you, and if it's not so, I'll apologize for that. But if I have the time, I'll try to see if I can find the specific cases that have been identified. I don't have any further questions, but I appreciate your time and your application. I wish you the best. Thank you, Judge.
Рухаємось далі.
Let's move further.
Пан Євген, вам слово,
Yevgen,
будь ласка.
over to you for your questions. Thank you, Ivan. My name is Mr. Mezentsev. And so, dear Oksana, Madam Oksana, I will continue my communication. So the Steven meant the following, that analytical specialists actually identified some failure of deadlines of to forward documents to this United Register. But I have some questions regarding property raised by our analytical specialists and our public, and we're going to discuss everything publicly. So in order to eliminate any possible concerns from the side of external observers. So first question is regarding residential house, which was built in the village. I don't know, sorry, the correct name of this village, and also the village is located in the Borispil district, and the land plot which was purchased by you, as its total area is 49 square meters, and it was located in the same village, and it's likely that the land plot is under the same house, and the value of that house was $1,700 USD dollars, and the land plot costed $2,350. And in this context, and in terms of the issue of possible gap between this price and the market price, could you please explain what was the reason of indicating specifically this price in your declarations? Yes. And that settlement, as of now, I have two land plots and one house, one land plot that's actually located under the house, and the second land plot, that's so to say vegetable garden, so which is adjacent to the house. All this property was owned by my granny, and in 2015 she was quite elderly. She was 90 years old, and she expressed her wish to give this all property to me upon agreement of all other family members. As this agreement was concluded between close family members, we didn't look at the market price of this property based on provisions of the legislation at the time. We reached out to evaluators of the property. They drafted the reports, the relevant reports, and the sums which they indicated in their reports, we identified as the price in our agreement for this property. Thank you. Clear. And then, if it's at Ukraine, if you have had close relations, why didn't you conclude the deed of gift? At that moment, back in 2015, there was no such provision of the law that's actually if there is there was no such provision for between granny and granddaughter to have a deed of gift. At that moment, if such deed of gift is concluded, you need to pay additional taxes. Yeah, so it will be an additional tax burden. Yes. Okay. One more question regarding purchase of BMW 3 produced in 1989. Of course, it was purchased back in 2009, so it means that it was already 20 years old. Of course, it's clear that the condition of that car could have been very terrible. But anyway, you purchased that vehicle and declared the price of 10 hryvnia. At that moment, it was a little bit more than $1. So even now, So the cars of this age and condition would cost not less than $1,500. So please tell us why you included this price in your agreement. So again, you explain that that's your husband who transferred to you the right of ownership. But again, why not gift? Why is this right to transfer of right of ownership? Yeah. Now, first of all, as far as remember, there was actually why we needed to re-register rights. Yeah, we don't need it. So we don't need to know why you need to re-register. Just explain why that price was specifically included by you in that agreement. At that moment, to our opinion, the easiest way to re-register rights of ownership of this car was to conclude a stock market agreement, so to say. I don't remember how to correctly call those intermediary agencies. They worked under umbrella of the vehicle registration offices. And it was convenient. You don't need to go separately to the notary and then to go there. So it helped us to save time and our efforts. As the property condition of the condition of that property was the same, so the status have not changed. It was within our family and it kept being within our family, so we didn't pay attention to it. Good, thank you. Tell us. During the period from 2016 to 2018, you failed to declare your husband's right to use this vehicle. Why did you do it? Did he use it or not? No, I will explain it. There was a similar question regarding housing, regarding absence of the right to use. And in 2016, declarations didn't have such an option to indicate both rights to use and right to own for one and the same object. It doesn't matter whether it's property, real estate object, or vehicle. As far as I remember, so NACP didn't require at that moment to indicate both right to use and right to own. Yeah, indeed. For 2016, it was a new provision. So in 2016, this declaration was submitted as for me as a candidate who participates in the competition. That declaration was vetted by the NACP, and the NACP actually forwarded to me a list of questions, and there was no question at all raised regarding this usage right. That's why next time when I filled in my next candidate's declaration in 2018, I did the same. So good, thank you. Then tell me regarding Toyota Camry produced back in 2006, which was purchased in February 2021. Again, I understand that that's a car all 15 years old, but it was purchased for the price of $5,360 in equivalent. But the market price for now shows from $4,500 That's the lowest price, but that's actually the terrible condition, and up to $13,000. So how you identified this price? Did you carry out any significant repairs of that car? Because it's clear that the price which you indicated was not that high. Unfortunately, I don't have any confirming document specifically for this vehicle. I don't know why. I thought that as my income allowed me to purchase even more expensive property. We don't need to look for this information. We don't know the sellers. So some strangers were selling this vehicle. We saw the advertisement. Why was the price so low and why they wanted to sell it so quickly? I don't know. I can't explain. But that car was not battered, but there were some damages. How to say it? Some consequences, some results of usage of this vehicle. For example, There were some problems with some key parts of the car which should have been repaired. And the last question regarding your property status, because the issues were concerned by specialists, analytical specialists. Again, in 2016 declaration, there was mentioned that at the end of the year, you have some savings at the amount of 300,000 of hryvnia and 25,000 of dollars. So altogether, if we take the average exchange rate, that's around $36,000 of dollars. But at the same time, your accumulated income for this full period since 2016 was $42,000 of dollars, a little bit excessive than $42,000 of dollars. Taking into consideration that back in 2016, you purchased that land plot from your granny for $2,200. So what were your living expenditures? What you used for it?
I didn't earn this money in 2016. These funds were accumulated and saved before 2016. And I was not a subject to declaration. It is not reflected in any declarations. And finally, but it's an important question. I want to ask about your capability to work in a team. If I analyze your previous work, your experience as assistant to a judge, the paralegal, you have a lot of legal experience. 15 years you were assistant to a judge, but all these positions, they indicate that you are used to work being responsible for your actions or just to fulfilling the tasks of your supervisor. And this supervisor is not reporting to anyone. Let's be honest. The judge is not reporting to anybody. He is independent or she is independent. And currently, you also fulfill functions of a judge. In legal sphere, it is an independent figure, which should be independent from any influence. Along with that, the work of HQCJ that you characterized as a wonderful composition demands a high level of standard of common work, joint decisions, despite of personal ambitions, your advantages. You need to make decisions for the benefit of the system in whole. Do you have an internal feeling that you will be able to work in a collective body and take collective decisions, or will it be difficult for you? I'm not going to assure you that I have a lot of collegial experience. It's really not very extended. I have been working as a judge for 1 year only, but this experience shows me that it is comfortable for me to work in a team, and I like to take collective decisions. When you take a decision on your own, you may neglect some minor things, and sometimes you may also interpret some circumstances in the wrong way. However, your colleagues can instead express their own opinion opposite to your opinion, and in such process, the best decision appears. Thank you, Oksana. This is all from my side. Thank you, Mr. Evgen. Robert, it's your turn.
Hello, Oksana. My name is Robert, and I have the honor to be the last to ask you a few questions. And it's not only the honor to be the last of today, but I can tell you that most likely I will also be asking the last questions to be asked by this whole commission, because you are our last interview. And as from the 1st of June, we don't exist anymore. And then there is no selection commission anymore from the High Qualification Commission of Judges. What do you think about that? That suddenly there is no commission with foreigners that is busy with selecting people for the High Qualification Commission. You just said, I noted down, it's going a bit better now in the judiciary. So we're making progress, so we can have more people coming in to the judiciary in Ukraine. Is it a good idea at present to abolish commissions like we have, like we will be abolished the 1st of June? Or is that a bad idea?
Я маю зізнатися, що я
I would
готувала
like to
промову
admit
відповідь на ваше запитання
that
на
I
своє
was
виборче
prepared
село, тому
to
що я
give
знала, що я
an answer to your
стану
question, and
кандидатом
actually, I've prepared to make my
в
final
вашій
statement, my final
виборчій
speech.
комісії у цьому складі.
Okay, well,
Да,
go
So,
ahead.
да.
I think it's
І
excellent that
тому,
please go ahead, but
по-перше,
I can exclude have more questions to you then. Please go ahead, make your final speech.
Stephen, you have something to ask, right? Please.
Yes, Judge, I promised I would get back to you after I took a closer look at the report. And I emphasize none of what I say here is to characterize you as a bad judge in any way. I don't think that's the fact. I think you're a good judge in many ways, but the report says during her short tenure as a judge, the candidate has committed violations of her professional duties, namely exceeding the deadlines for sending electronic copies of court decisions to the Unified State Register of Court Decisions. I don't know the details of how important that is, but again, it's kind of an unusual characteristic of someone who hasn't served on the court for very long and is trying to gain a good reputation. Why do we see those kinds of violations so early during your tenure on the court?
ці порушення пояснюються, на жаль, тією
these
ситуацією, яка
violations
склалася в
can
нашій
be
країні.
explained by the
Я
situation
знаю
we
про
have
ці
in our
рішення
country.
і їх кількість
I
є в
understand
мене
what decisions you're talking about. I have a
на моєму
number of
робочому
such
місці.
decisions,
І пов'язано з цим,
and
що восени в нас
it is
дуже
connected
часто вимикали
with the
світло,
fact
і
that
просто
in
в кінці
autumn we
робочого
didn't
дня в
have
мене не було
energy,
можливості
power, and in the
завантажити
end
ці
of the day,
рішення
I did
в
not have an
систему, і тому я
opportunity to
зробила це на
download
наступний день,
this decision
вже
into the
очевидно з
registry, into the
порушенням
system.
закону.
And that's why I did it on the next day, which unfortunately resulted in violation of the timeline.
Robert, I'm sorry to have asked the last question and
No,
deprived you.
no, there's still my turn, Stephen. I'm not yet finished. I didn't even start.
Sorry, I didn't mean to interrupt you. I apologize for that. Please go ahead, if that's okay with the chairman, of course.
Yeah, totally fine.
Yes, because I asked a question and then Oksana said, well, I prepared myself for the answer and that is in my final speech. And then I said, well, please go ahead with your final speech. Please go ahead.
I'm sorry. I'm sorry for that.
Так, так от,
Yes, okay, I'll continue.
це ще не заключна промова, однак
No,
я
it will
дуже
be
хочу вам всім
not my
подякувати за ту
final speech,
титанічну працю,
but I
яку
would
ви
like
зробили
to
для
thank you
нашої
for all
країни.
titanic work you have
Я
done for our
вважаю,
country.
що
And I think
ця відданість вашої
this
комісії,
dedication
вона
of your
має
commission
дуже дієвий результат
has
у
been
вигляді
very
ВККС
effective.
в тому складі, яка
The
активно
composition
включила
of
свою роботу,
HQCJ
яка вже
is very
провела
active. They
дуже
have
велику
conducted
кількість процедур і
a
наразі
great number of
продовжує їх
procedures
проводити.
and continue to do
І я
so.
дуже сильно сподіваюсь, що
And I
саме
really
ваш
hope
приклад і ваш
that your
оцей
example
вдалий, як на мене, досвід
and your
добору членів
experience of selecting candidates to the HQCJ by engaging international experts will push our legislator to make amendments to our main legislation and change the provision. And I hope that the Selection Commission will be created in future and it will consist of international and national experts. I had an honor to work in the High Anti-Corruption Court. I know who has been selected there, also with the support of international experts. I have been following the competition, how it was conducted, and how the international experts scrutinized each candidate. And I think such approach and such attention will improve and increase the trust to the judiciary. Several times I have heard from my colleagues that we have two types of judiciary. Please don't be offended. But I've heard from the lawyers, we have the judiciary of the High Anti-Corruption Court, and we have judges separately. And today I see the positive result when the commission consisting of national and international experts is being engaged. Have you heard it from the lawyers who practice law in the High Anti-Corruption Court? Well, in fact, there are not so much acquittal acts. But yeah, I understand your point. Thank you very much, Oksana.
Yeah, again, I'm interrupted in my turn now by our president, Mr. Mishenko. It's always the same. And the point is, of course, that I don't know whether there should be a new commission. I'm only a foreigner that has been asked to do a job, which I'm happy to do. And I'm sure that all the internationals, the three of us, have been very, very happy and honored to do this work. And we are happy and honored to be helping Ukraine in those difficult times. But of course, this exercise cannot go on forever. At a certain moment, it has to be done by Ukraine itself. You cannot always have foreigners to select people in the judiciary. If, for instance, in the Netherlands there would be a Ukrainian in a commission to select a judge, there would be a revolution here because that people would find it very, very strange. Now I was triggered by the fact that you, at the School of Judges, you give a course in integrity. Is that correct? Is that what you said? Well, that seems to be perfect because then apparently
yes.
you're learning the judges in Ukraine how to deal with integrity issue. What are you learning the judges in this course?
Я уточню, що цей курс я викладаю для
I'm teaching this course to the staff of the court. I think their work is very important for the face of the court, so to speak. The only thing I would like to explain them that integrity does not only have a financial component. It's not only about corruption in the court, whether it exists or not. It is also the question of conflict of interest and making a decision in the conflict of interest. It is giving response to particular situations when there is a conflict. And I have received an interesting feedback from participants when they said, well, I'm a professional. I can make a decision even if I'm taking a decision against my acquaintances. And I'm trying to explain them. Regulation of the conflict of interest does not doubt your professionalism. This is your attitude to the picture which is being created by situation. Also, we also consider different ethical moments which arise during the work. And what I like most of all, I try to create practical situation for them and to give them a chance to think, to wear the shoes of judges and to decide how to act in this or that situation.
Well, thank you, Oksana. I hope you give this course to many, many judges in Ukraine and outside of Ukraine, because I don't think there are so many courses on integrity in any judiciary. And I know of a few countries where they urgently need such courses. And I think I have asked my last question to you, unless we have a further round, but I leave it to our dear President, Mr. Ivan.
Thank you, Mr. Robert. So, do you have any further questions, colleagues? Чи будемо завершувати?
Are we
Немає
going
запитань?
to conclude to finish this interview then?
Ну, от, пані Оксана, і
Okay.
добігає кінця наша співбесіда.
This is the end of our
Дякуємо
interview,
вам
Ms.
за цікаву
Oksana.
розмову,
Thank you for
за
such an
ваші відповіді.
interesting conversation, your
Чи можу
answers.
я сприймати вашу заключну промову як заключну промову?
Can I
чи як
accept your
відповідь,
final
Роберт?
statement
Чи ви
as your
все ж таки
final
хочете
statement,
ще раз
or it was
завершити
just an answer to
співбесіду? Якщо
Robert?
так, то будь ласка.
If yes, if you're
Буквально
willing
ще
to
два
add
речення
something,
я
please
сказала
go.
про міжнародних
I have
експертів
mentioned
світових.
international
Хотіла
experts,
подякувати
and I would like to thank our
національних
national
судів за
colleagues
те,
from
що ви
national
знайшли
courts
той
as well.
час,
Thank you for
сили в
finding
собі,
time, efforts,
бажання долучитись
willingness
до цього процесу.
to join this
І
process.
незважаючи на результат
And
цього
despite
конкурсу
of
для
the
мене, для
results
мене
of this
є честь
competition for
взагалі
myself,
в
it
ньому
was
прийняти
really an
участь
honor
і
to
мати такий
take part in
досвід
it and to
спілкування
get
з вами.
such experience of communicating with you.
Дякуємо вам, пані Оксана.
Thank you, Oksana.
Всього найкращого.
We wish you
І на
all
цьому
the
будемо
best,
завершувати
and
нашу
this
співбесіду.
is the end of our interview.
Дякую, до побачення.
Goodbye.
Bye.